Recording.
Great. All right, we are here to publicly deliberate the matter of Daniel and Jennifer Salak, 21618 Orwig Road, Freeland, Maryland, 21053. It's case number 22-077A. This was originally a petition for variance for relief from section 415.3C.1 of the BCZR to permit storage or parking utility trailers in the residential front half of the lot in lieu of the rear half, and storage of 3 utility trailers in lieu of the permitted 1. A May 18th hearing was held before the administrative law judge in which the petition of variance had been denied. We then had a de novo hearing before this board. During that hearing, Ms. D'Amelio from People's Counsel was present, and the petitioner, Mr. Salak, actually appeared pro se, though he did a good job. So here we're dealing with several issues, and if I could help to shepherd us through like the first issue here, there had been some correspondence from People's Counsel, and also the issue was sort of dealt with before the ALJ, and that being that this case was originally styled as a petition for variance as allowed in section 307 of the zoning regs. Correspondence from the People's Counsel laid out case law showing that basically variance relief was available for area and height restrictions. So the question would be, is the variance relief even possible in this situation? Looking at the statute that's involved, the 415.1C, the issue for trailers and mobile homes, a good portion of this section actually deals with setback and things for mobile homes. If they were, I see it being logical if one were in fact asking for variance relief from how far their trailer had to be from a road or from another structure. It's not the case here. Here we're dealing just with a number and where it can be located. So I believe there is a strong argument that the variance relief isn't even possible through section 307. But assuming for a moment that it's what, if it were, that's what they did below before the ALJ, employing the Cromwell standard, I don't believe there really was even an effort to conform with a Cromwell analysis to showing that there was uniqueness that facilitated such a variance, or any kind of a practical difficulty that wasn't self-imposed. I think the testimony that we heard, basically, this is for the convenience for the storage of recreational vehicles and the trailers used to transport them. That being said, I don't think that's the end of our examination. Part of the situation, the gravamen of why we're here is because of code enforcement. Code enforcement issued citations. There was some questions as to whether the trailers that were on this property were in keeping with what the statute had envisioned to prohibit. At the end of the hearing that we had, I did ask Ms. D'Amelio if she agreed that in the interest of judicial economy, if we were to treat this as a petition for special hearing, would it not be beneficial? For review, a petition for special hearing is akin in circuit court to a declaratory judgment, where someone is asking whether or not the law applies to a specific situation to guide them either in future development or for code enforcement. There was some confusion as to how this case was filed. We heard from the petitioner that some of the documentation that we had in the file was not the original documentation that had been submitted in the zoning office. So there was questions whether or not it was really a request for variance. I think through the candor of the petitioner, he really didn't want a variance. Basically, his arguments were based more in a special hearing situation. Looking through the statutory definitions, his argument was, in fact, that the trailers that he had on his property, and he showed pictures of these trailers, his argument was how they were constructed and saying was not in keeping with 415.1C, which had been cited on the code enforcement situation. So the first question I have of my colleagues, do you have any disagreement with us going forward and just treating this as a petition for special hearing and clarifying this question of law for folks once and for all so that we can proceed? Mr. Lauer, do you have any problems with proceeding in that fashion?
I do not.
Ms. Bernardi?
I do not. I think it'd be beneficial.
Okay, so basically, I think we can put in whatever decision we come to that variance relief, we can say one really isn't possible. And if it were possible, that the Cromwell analysis would not really apply and hadn't been satisfied anyhow. So in the interest of trying to figure out the question that the petitioner has, and I think code enforcement has as well, is whether or not the type of trailers that he has on his property are the same type of trailers that were thought about when putting forth the prohibition in 415.1c. Now, as I said before, the petitioner in this case, to coin the popular term, he he understood the assignment. Basically, he went to the heart of the definitions of what is a trailer or a mobile home. And I would have to agree with him that I believe a good portion of Section 415 with trailers and mobile homes seems to deal with the more residential mobile homes, dealing with setbacks and things of that sort. Um, what is problematic with that is that when we go to the definitional sections of what a trailer can deem to be, the last sentence of that definition found in section 101.1 states a trailer includes smaller structures transportable by a pickup truck or similar vehicle. So that kind of throws in some gray there, saying that perhaps even though the rest of section 415.1 deals with mobile homes and trailers that would be used for office or for residence, that this sentence here seems to encompass perhaps something that's smaller and that could be pulled along. I think that issue is more important to clarify when dealing with the validity of a future code enforcement violation that had that citation on the code. And I say that because I'm going to quickly pivot to section 415A.1. And 415A.1 deals with recreational vehicles on residential lots. And since we're kind of doing a special hearing situation here, from what I understood from the petitioner, he just wants to know what he can and cannot do. So I think it's going to be reasonable for us to pivot and look at that section, which has its prohibitions for residential recreational vehicles, things like boats and things that would transport boats. And again, when looking at section 415A, one might say, this deals more with boats and things. This isn't trailers. Until again, we go to section 101 and we look for the recreational vehicle and boat definition. And looking at the title, you would say, that deals with boats and recreational vehicles. However, when we go to subsection E of that definition, it states a travel trailer is deemed to be a recreational vehicle. Subsection E states a vehicle portable unit mounted on wheels designed to be towed by a passenger automobile or pickup truck. Now, reading that for me seems to hit the nail on the head of what we have here. And we have that by the very candid testimony of the petitioner. The problem with that, I think, or a code enforcement situation, is that a trailer that hauls lawnmowers that doesn't have the lawnmowers on it is not going to look different from a trailer that, in fact, is going to haul recreational things. In this case, from what we do know, I think it's clearly a travel trailer under 415A.1 and then through the definitional section of 101.1 for recreational vehicles in subsection E. So I think that's the one that fits the best. I think there is an argument to be made from the definitional section in the last section of trailer for 415.1.c to say that it is on board. I bring up both. I said, but through a petition for special hearing, the answer from us is that through both of these statutes, you cannot have what's there unless you put it in a garage. I'm sympathetic to the petitioner because I believe that the code section that his code enforcement citation went under is misleading. And basically, even, if that were to be dismissed, there's nothing stopping code enforcement for going out, doing a new citation and putting on 415A.1. Um, and we'd be at the same place. And I think the petitioner appreciates that, because he just wants to know what he can and cannot do. And since this is a petition for special hearing, first of all, I'm going to say, I think I'm just going to wager that the three of us might be in agreement as to the recreational vehicle part. Are we all three on board that that's the section that really applies the most?
I am.
I am as well.
Okay, so in any decision that comes forth, we can have that. So the gray area is whether or not we want to pretty much ignore the obvious statutory intent of 415.1 and go with the last sentence of the definition of trailer to say that that does in fact imply to these. I don't know if it matters either way. I really don't know. Ms. Menard, do you have any thoughts on whether that one actually applies by a stretch or nay?
Well-
I think it applies because of that last sentence. And if we don't address that, that can be a potential issue.
All right, yeah, I think that is the safe bet, because even though the statute reads one, when you get into the heart of the definition, which is in, as what's it called, in peri materia of the other statute, that it basically lets us know that they're including things other than like a residential trailer, because they put it in the law and they put it as the last sentence to say, oh yeah, by the way, we mean this stuff too. So I think that's sort of what took place. Mr. Lauer, are you in keeping with that, sir?
I am in total agreement.
Okay, so I think the way we can fashion our opinion is basically say it's not a variance. We're not sure variance relief is even possible for it. If it was, Cromwell doesn't apply. We see the most applicable description of what's on the property as being the 415A.1, but also we will comment that the last sentence of the definition of trailer seems to incorporate it into the 415.1C that's originally on the violation. I guess in future, if anyone listens to what we do or what we write, it might be a good idea for code enforcement in a future situation if they were more specific, because I think that would remove the gray. Because I do not fault the petitioner at all for being somewhat confused about what is there, because when reading, as he stated, the original parts of that statute deals with trailers and mobile homes and setbacks and things of that sort. It seems to be something that does not apply to him. But for a deeper dive, well, our job, that it seems to, by just a smidge, it does apply. So is there anything further from my colleagues that you would like to add? Are we unanimous in the way we have gone about this here today?
I am in total agreement. I think your analysis was very good and very well reasoned. I would like to say though, and I don't know if they're listening, I don't see the attendees, that the petitioner did a really good job, and I am sympathetic to his concerns, and I would hope that he had asked, I think at the end, that the county work with him in a time framework. And I think Ms. D'Amelio said something about contacting him, and I would hope that that can be accommodated. That would be my comment.
All right. And anything, Ms. Bedardi?
No, I think that the way you've laid it out is very logical, and anyone, if they were to read this opinion, they would know the rationale. And I agree with the advice for code enforcement, because a layperson would be confused if you've received this type of notice.
All right, fantastic. Well, I will fall on the sword and volunteer to write this one. And
Thank you.
and Mr. Lauer, like you're done for the day, and Ms. Bernardi, I'll see you in a while.
Yes.
All
All
right,
right.
folks.
Thank
All right,
you.
have a great day.
Good day.
Thank you very
Bye.
much.